police took me from my home over tweets. No charge, no crime. 6 days. In 2021, the police finished investigating themselves over it. This is their conclusion in their own words. A public complaint decision. 102 pages. Signed by the Deputy Chief of Police. Page 101. Look at the words they chose. The circumstances of this case are something one could imagine happening in a police state, but not in a free, democratic country which is governed by Charter of Rights. That's not my phrase. That's the police describing themselves. And why it should matter to you, same page. A person who poses a very low risk to others and suffers no mental illness could be detained by police for social media posts. Demonstrates how vulnerable members of the public are to unlawful deprivations of liberty by police officers who abuse their authority. Their words about everyone. So what exactly did they find? Accordingly, on behalf of the RNC, I apologize to A for this unlawful detention, which represented a serious and unwarranted deprivation of his liberty spearheaded by an officer acting in bad faith. My complaint? Proved. The detention? No lawful authority? Ordered in bad faith. The penalty? Dismissal. Except he'd already retired. Nothing happened to anyone. So that's the story? No. That apology is where this story starts. Every document in full. paradigmslip.ca/bad faith. To understand what happened to me, you need 3 days in April 2015. April 5th, Easter Sunday. A police officer shoots and kills a man named Don Dunphy in his home. Over tweets, the officer had gone there to ask about it. It's national news. People are angry online. I was one of them. But I wasn't just angry. I was one of the first to point out that Dunphy's tweets, read in their full context and proper order, contained no threat. I was questioning why an officer went to that door at all, and whether he was competent to be there. In my view, that's what put me in their sights. The force's own record backs the timing. The caution about me cites my Twitter activity since the death of Don Dunphy. Yesterday. The next evening, this email goes out. Andrew Abbas has been very active on his Twitter account since the death of Don Dunphy in Mitchellsbrook yesterday. Sent to every member of the provincial police force. Attached, screenshots of my tweets and my photo. April 5th, a man is killed over tweets. April 6th, I'm flagged to the entire force over that day's tweets, the groundwork. The tweet they later point to as justification didn't exist yet. I posted it the next morning. By mid-afternoon on the 7th, police were at my door. Who sent that email? And what did his own colleagues think of it? Documents in full at the link. paradigmslip.ca/bad faith. The night before police came to my door, the people paid to assess threats looked at me. Here's what they wrote. The caution email, sent force-wide at 7:54 p.m., April 6, 2015, by a staff sergeant, almost 4 hours after a shift ended. My tweets, my photo, a warning to use caution around me. Now watch who picks it up. The officer who had shot Don Dunphy the day before. Here's how the force's own decision describes why he went to that man's home. He had attended the residence of an individual in response to a Twitter comment that the individual had posted online relating to politicians. A residence over political tweets. The day before, they came to mine. He forwards the caution about me to his counterpart in the Premier's protective detail, an RCMP officer. And that officer sends it up to the Premier's Chief of Staff with his own assessment. Abbas is in Corner Brook and makes no direct threats beyond bluster. No direct threats. Bluster. In writing. That night. To be fair to him, a separate decision found that forwarding the email was for legitimate law enforcement reasons. Part of his job protecting the Premier. That's the point. Nothing here was out of order. And the answer that came back was still no threat. The unit whose job is protecting the Premier? No direct threats. The investigation later found I had no criminal record, no weapons. And the next afternoon, I was detained anyway. One more thing about that email. The man who sent it swore, at a public inquiry, that members of the Criminal Investigation Division had brought my tweets to his attention. The officer he named strongly denied it, and the force's own decision found that his claim was a deliberate falsehood under oath. So how does a man with no charges get taken from his home? No notes? No assessment? Next. Every document, in full, paradigmslip.ca/badfaith. April 7th, 2015. Officers at my door. No warrant, no charge, no crime. Their own file tells you how, hour by hour. 10:01 a.m., a staff sergeant opens an uttering threats file on me. Nobody had complained. It goes to a CID investigator. She reads my tweets and tells him there are no grounds. She would not be arresting him because the case needed further investigation. On her account, the only time in her career she ever disagreed with a supervisor. She was right. No charge was ever laid. Not that day. Not ever. Years later, the force investigated itself. In its findings, the staff sergeant is Officer X, and I'm A. What it called most telling, the officers were acting pursuant to an order of Officer X to detain A, and that his detention was a foregone conclusion. A foregone conclusion. Before anyone knocked. Now the two things I promised you. First, the notes. The staff sergeant who ordered it made none. The decision gives that its own heading. And the detailed count of how I supposedly appeared, written the next morning, at 11 minutes past 9. It grows for years later. Second, the assessment. Criminal Intelligence did run one on me. It was emailed up the chain at 4:38 that afternoon, after I was already gone. The decision's finding? The order to detain me came prior to the completion of the threat assessment by the CIU. They decided first. They checked afterward. Their own record shows an officer asking whether they could get a warrant to enter my house. The answer, at 20 past 2, no court order exists that lets police enter a home under that act. He was told to wait for me to come outside, so they waited. I took photographs. The phone stamped the time into every file. 11 minutes past 3. He's at my door, looking down, taking a card out of his pocket. 27 past 3, 16 minutes later, and he hasn't gone anywhere. Now he's looking straight at me. His hand is resting on his duty belt. Force policy is that a uniformed officer on patrol carries an issued firearm on that belt. CERT says officer spent 15 to 20 minutes at that doorway. My phone says 15 minutes, 36 seconds. 1 minute past 4 at the hospital. An officer writing in his notebook. And what those 6 days cost. I had a court date on April 9th, a charter challenge I built myself. The newspaper that week, Abbas, was unable to attend the scheduled hearing because he is currently being detained at the Western Memorial Regional Hospital. It took me 2 days before my day in court. 6 days in a psychiatric unit? What did they actually find? Next. Every document in full, paradigmslip.ca/badfaith. Last episode, I asked what 6 days in a psychiatric unit found. The answer is already there, on the first page, written before the 6 days began. Nothing. Everything else in this series is a public document. These ones aren't. These are my own medical records. I blacked out the private parts myself, and I'm showing you the rest, because they're mine to show. April 7th, 2015. Triaged at 3:51 in the afternoon. Registered at 4:03. The record books psychiatric consult from 5 o'clock to 5:45. The conversation I remember lasted about 5 minutes. What the other 40 were, I can't tell you. Here's why she was asked to see me in her own hand. brought in by the RNC for assessment under the Mental Health Act, ordered in reference to several tweets expressing anger at the Canadian government for its foreign policies, and also at the NL government in response to the shooting death of an individual on Sunday in eastern Newfoundland. Anger at two governments. That is the reason on the page. Then she examined me. No past psychiatric history, not on any medications, intelligent and well-spoken, alert and oriented ×3, normal speech, eye contact, thought process, goal-directed and logical, no loose associations or flight of ideas. Thought content, denies any mood symptoms, no suicidal ideation, no homicidal ideation, no hallucinations. The triage note that afternoon reads, patient has made comments on Twitter with regards to harm to others. She also wrote down what I was doing there. He has a case/hearing in Supreme Court on Thursday, April 9th, where he is representing himself and is working on the prep. He's brought his documents with him. And then on the diagnosis line, no Axis 1 diagnosis made yet, R/O paranoia. R/O is clinical shorthand for rule out, a possibility to be excluded, not a finding. At 10 to 6, a different doctor, the emergency physician, signed the certificate that held me. 4 reasons are written on it. The first one is, patient facing forensic/court on Thursday. The second is, some symptoms consistent with paranoia. The first reason they wrote down for holding me was my court date, the one she had just recorded I was preparing for. There are 2 signatures on that certificate, 5 minutes apart. One of them was not there when I was given my copy. Next. Every document in full, paradigmslip.ca/badfaith. Two signatures on one certificate, 5 minutes apart. Here is what the second one does, and when it actually appeared. Under the Mental Health Act, one certificate holds you for 72 hours. A second certificate, signed by a second physician, holds you up to 30 days, counted from the moment the first one was signed. One signature is 3 days, 2 is a month. Mine are timed on the page, 10 to 6, 5 to 6, both dated April 7. That same evening, the psychiatrist who assessed me wrote my admission orders. On them, in her hand, certified with one signature, 1, that night. The next morning, at 8:30, she signed my care over to a different doctor. Separate page, same hand. And then, dated April 8th on the progress notes, the patient has been certified with 2 signatures as of, and which assessment it rests on. Assessment done last evening by me in the ER. Her assessment, the one from the night before. The Act says each signer must have personally examined you. Both certificates say so in print. I personally conducted a psychiatric assessment. The first one times that examination at 5:31. The second times it at 5:55. The same minute the certificate was signed. 4 officers came to my house that afternoon. The force's own decision. They were dressed in full RNC uniform and were armed, as per RNC protocol. One of them later told investigators he was with me during transport and at the hospital. The rest of this is mine. No page carries it. That first assessment happened in a secure room. The doctor in front of me, 3 officers behind him in the doorway. The second one that evening was one-on-one, about 5 minutes and not much discussion. Here is the reason the second certificate gives, that I was brought to the emergency room by the RNC after I allegedly made statements on Twitter expressing anger with reference to the fatal shooting. Allegedly, her word, on the certificate that held me. And printed at the foot of that same page, keyed to the line where those reasons begin, not her writing, the forms, the facts observed by the physician must be distinguished from those that have been communicated by another person. That is the act, printed on the certificate she signed. The next day was my court date. At 4 o'clock, the hospital wrote that I could have a pass to attend with a police escort. I never got there. I was told there was nobody with the authority to sign me out. The hospital said yes, nobody could sign the paper. 6 days in that unit. I've told you they found nothing. Next, the 4 people who wrote it down. One of them was my own doctor. Every document in full. paradigmslip.ca/badfaith. The plan, written the night I was admitted, was 3 days. Admit for assessment under the Mental Health Act for initial 3 days. They kept me 6. Here's what the nursing staff recorded across those days. Appropriate behavior throughout. No evidence of impulsivity or aggression. Ward privileges used without problems, and each time he came back on time. At no stage did he express any suicidal or homicidal ideation. On the second morning, my care passed to a different psychiatrist. He wrote the discharge. On successive examinations, pleasant and cooperative. Opposed to the detention, he was aware of his rights. Mood euthymic. Screened for hallucinations, 4 kinds. None. He had read every one of my tweets. His note, I was adamant that he did not have any death wish when he had said, "Come and get me, you cowards," and had identified aspects of foreign policy which he had opposed and which he was going to take to court. I did not feel that his judgment was compromised. He called my family doctor. What my doctor told him is in the file, in the third person, the way he wrote it. Mr. Abbas has been an activist all of his life, and at no point did he find him to be aggressive. There was also no suggestion of psychosis in him at any point in time. Then, in his own words, I decided to ask for a second psychiatric opinion. In her estimation, he was not psychotic, nor was he a danger to himself or to others. Everything so far is on a page. The next part isn't, so I'm telling you it's mine. 2 of the doctors who assessed me recognized what the act was being used for. Not to treat a condition, to hold a man under a law written for something else. Not medicine, a use. I had applied to the review board. My hearing was listed for Thursday, April 16th at 1 o'clock. On the 14th, they canceled it. The notice gives the reason. As the applicant has been decertified and discharged, it never got tested, it just stopped. On both of those notices, the applicant is named David Abbas. Here's the treatment I received in those 6 days, in the hospital's own words. He was not treated by way of any psychotropic medications and only received a nicotine patch. In the discharge form, under most responsible diagnosis, no Axis 1 diagnosis. Pre-admit comorbidity, NA. Post-admit comorbidity, NA. Secondary diagnosis, NA. His certification was discontinued and he was immediately informed about this. That was April 13th. While I was still in that unit, the courtroom spent a day on it. Not on whether I should be let out, on whether a court should even hear the reasons they had for holding me. I was there. I never got to say a word. What the hospital's lawyer told that judge is next. Every document in full, paradigmslip.ca/bad faith. Three days after they took me, on April 10th, a courtroom spent a day on it. I had filed for habeas corpus, the oldest remedy there is. Bring the person before the court and justify holding it. Before anything else, the hospital's lawyer asked the court not to hear it at all. What that came down to? A man who might get the same hearing via habeas corpus a few weeks faster than, following the legislative procedure. And my lord, that is the classic floodgates situation. Then he told the court what would happen if the judges heard it anyway. If we proceed with this hearing, we're going to go behind the certificates. There's going to be evidence-led. The notes, the medical records, the actual observations of the doctors at the time. All of it, he said, will be before my lord. He had the doctors, too. One was in the courtroom. For the other, an emergency room physician who worked the night shift last night. I have his number to contact him. And then this. He's entitled to privacy with respect to those records. What the doctors observed is going to be before the court, and that may or may not accord, and I say that because I do not wish to disclose, with what counsel is telling the court. He did not say what they saw. He said it might not match my lawyers, and left it there. I was in that courtroom. My own lawyers were not. They appeared by video from St. John's. He said that with me sitting in the room. The only way I had to reach my own counsel was the facilitator beside me. One of the difficulties in having the applicant separate from his counsel. She asked for a moment and got it. When we came back, my lawyer told him why. He had some concerns that the court may have the wrong impression based on some of the comments before we broke. That I wasn't trying to withhold anything about his treatment this week or about his health history. I never got to speak in that courtroom. That was the only thing I said in it, and it took 2 other people to say it. My other lawyer answered the substance. The certificate, she said, is the only document that Mr. Abbas has received to tell him why he is being detained. The Act asks for a mental disorder first, then for a risk. It is the reverse here, an allegation about something said on Twitter, so therefore let's hold and review and see if he has a mental disorder. That is not the law. The judge adjourned and came back. His decision says at the outset, at this point no evidence has been heard, and then, I feel that I am bound by the decision of the Supreme Court of Canada and I must dismiss the application for habeas corpus. He sent me to the review board. The following April, a court of appeal read this same transcript. What it said is next. Every document in full, paradigmslip.ca/badfaith. A court of appeal read that same transcript. They heard it on April 12, 2016, a year after that hearing. The decision came on April 13, 2017. First, the order changed. The one that came out of that hearing said the court does not have jurisdiction. After my appeal was filed, it was amended to read that the court declines jurisdiction. One says he had no power to hear me, the other says he had the power and chose not to use it. The Court of Appeal recorded that in a footnote and passed no opinion on whether it was proper, or on whether he still had the authority to make it. Then it disagreed with him on every point, that the Act's procedure was not complete, comprehensive, and expert for what I was raising, that he should not have declined to exercise his jurisdiction, and on the certificate itself, without the existence of the piece of paper properly completed, the authority does not exist. It found he owed a duty to look further into the circumstances that, to say the least, appear to be extraordinary, and that the courts must always be there for the vindication of the citizen with what he or she views as the wrongful exercise of authority. And then this: if anger about political events and words of defiance to authorities are dealt with as signs of mental illness, then our society is in a dangerous place. Such anger and defiance are characteristic of political dissent. As the history of authoritarian societies has taught us, confinement in a mental institution is a particularly insidious way of stifling dissent, directly and through intimidation. The same paragraph asked 3 questions on the record. 2 of them. Was this the intent of the police in this case? Did the physician simply lend their authority to what the police asked them to do? It answered none of them. What it did decide, it put plainly, on whether I should have been allowed to challenge the confinement at all. The applications judge, in effect, said no. In this he committed a fundamental error. Then, Mr. Abbas was denied his day in court. And then 5 words. He should have had it. Then the remedy. The appeal is allowed, and the decision declining to hear me is set aside, and the matter is remitted to the trial division for the continuation of the hearing. 2 years to get back to the day it should have started. It would not decide the rest itself, not whether the detention was in fact lawful, because the record to enable a proper determination in that regard may be incomplete. Taking the preliminary question first had diverted consideration from what was needed to make a determination on the merits. The objection made before anything else is the reason nothing had been decided 2 years later. So it went back down to be heard properly. In the 3 days before it was, 2 letters arrived from the police. Next, every document in full, paradigmslip.ca/badfaith. The Court of Appeal sent it back to the court that had declined to hear it. The hearing was set for July 7, 2017. My lawyers filed a factum, and it put 3 questions to the court. The last one: were my rights under Sections 7, 9, and 10 of the Charter violated? 14 of its paragraphs were about the police, written in the third person, the way a factum is. That there were no legal grounds for the RNC to apprehend the applicant on April 7, 2015. That there had been no certificate of involuntary admission and no court order. That the apprehension was done without legal authority and consequently was an arbitrary apprehension and detention. Then the law it rested on. The Supreme Court of Canada, in Grant, a detention not authorized by law is arbitrary and violates Section 9. In the factum's conclusion, there was a breach of Section 9 of the Charter. The Act also sets out what an officer has to tell you when he apprehends you. 3 things. First, the reasons for his or her apprehension or detention. Second, that he or she is being taken to a facility for an involuntary psychiatric assessment, and third, that he or she has the right to retain and instruct counsel without delay. I was never given the reasons, only that a doctor wanted to see me, and on my own affidavit, filed with that factum, I was not told the third. 3 days before the hearing, a letter arrived from the counsel for the chief of police. It quoted the Court of Appeal back at my lawyer, that I had sought the vindication of having a Supreme Court judge affirm this, and then the chief of police was not named as a party to these proceedings. The next day, a second one. Unless you request that the court add the RNC as a party to this application, I must insist that you strike out paragraphs 15 to 28 of your factum. Both letters were copied to the court, 14 paragraphs, 2 days before the hearing. I had been forced to leave my family and move to Corner Brook for this. More delay is what they were offering. The judgment came 10 months later. I have restricted my consideration of this matter to a review of the actions of the two respondents, particularly the first respondent, and not members of the Royal Newfoundland Constabulary. Neither that organization nor individual members were named in the originating application. But the charter question was never only about the police. The judgment records, on its third page, what I had filed in April 2015, that my detention was unlawful, and that my rights under Section 10 of the Canadian Charter of Rights and Freedoms were violated by the actions of the respondents. The second respondent was discontinued before the hearing. The hospital was not. That question is on page 3, and the judgment never comes back to it. What it did decide, decided on paper. By then, 2 doctors had sworn affidavits of their own. What they said, and what the judge did with them, is next. Every document in full, paradigmslip.ca/bad faith. Two years and 2 months after that afternoon in April, both doctors swore affidavits. What the certificates did not say, they now said. The emergency physician who signed the first one explained the word he had written. His primary concern when asked to assess someone, he swore, is the well-being of the patient in front of me. He had suggested that he engage in a voluntary admission for the purpose of assessment, as I believed he suffered from paranoia. Mr. Abbas, as was his right, did not consent to a voluntary admission. Then the sentence the certificate does not contain. I did not have any real concern with him posing a risk to the general public, but I did believe a confrontation with the police risked harm to others. That is the man who signed the first certificate. The psychiatrist who signed the second swore hers 2 weeks earlier. That April, the Court of Appeal had asked whether the physicians simply lend their authority to what the police asked them to do. In June, she swore, I did not detain Mr. Abbas because the police brought him to the hospital. She said she was able to exclude most mental disorders, but wanted longer than an emergency room allowed. My belief at the time was that an involuntary admission was in his best interests. She had also sworn this. I was not able to determine if his anger and concerns with the government being after him were within the normal range, and understandable as he had just been taken in custody by the police, or were in the abnormal range. Her certificate gives one reason. Further observation was necessary in order to establish Mr. Abbas' personal safety as well as public safety. When the judge read it, the second certificate does not identify any mental disorder. She was discontinued as a respondent before the hearing. The judgment proceeded against the hospital alone. He read the first the same way. It states symptoms consistent with paranoia, and against that, no facts are set out to support this statement. And the rule, a practitioner must provide written notes with sufficient factual detail to support the issuance of the certificate. The affidavits were sworn in 2017. The certificates were signed in 2015. The burden was never mine. It sat with the person or authority that detains to establish that the deprivation of liberty was lawful, and with it, a duty to make a return to the court of all documents and other evidence pertaining to the lawfulness of the detention. In the finding, the hospital has not produced evidence to show that the detention of the applicant on April 7, 2015 was lawful. The application is granted. An order of habeas corpus is granted, 3 years and 20 days after they took me. No court examined what the police did. What the judgment says, and what it doesn't, is next. Every document in full, paradigmslip.ca/bad faith. Habeas corpus. A judge does not get to decide whether to hear it. That is what makes it different from everything else. The judgment quotes Blackstone, calling it the great and efficacious writ in all manner of legal confinement, and the Newfoundland Chief Justice, writing in 1829, saying it was so much the right of the subject as to render it compulsory on the judges to grant it. It is also in the Charter, and the judgment sets the section out in full. Everyone has the right, on arrest or detention, to have the validity of that detention determined by way of habeas corpus, and to be released if it is not lawful. Two halves. Remember the second one. I filed on April 9th, 2015, 2 days after they took me. On April 10th, the judge heard it and did not decide it. The court declines jurisdiction to hear the application because the MHCT Act provided a complete, comprehensive, and expert procedure. On April 13th, I was discharged. The 6 days were over. Whatever the writ was going to do for me could no longer do the second half. 2 years later, the Court of Appeal called that a fundamental error. It took another year to get back to the question. April 27th, 2018, I won. The application is granted. An order of habeas corpus is granted. Here's what it decided: that the hospital has not produced evidence to show that the detention of the applicant on April 7th, 2015 was lawful, a burden not discharged. It gave me one other thing. The applicant has awarded his costs on a party-and-party basis. My lawyers were legal aid. Nothing was ever paid to me. Not then, not since, not for any of it. And here is what it does not say. It does not say the detention was unlawful. It does not say any right of mine was breached. The charter argument is on its third page, in the paragraph that records what I filed, and the judgment never comes back to it. I read it as a ruling that what they did was unlawful. I filed it that way for years. The decision does not say it. So I had the first half of the right, 3 years late, and the second half was never available. Somewhere else, 2 days before they took me, a man was shot dead in his home by a police officer. What got written down about that is next. Every document in full, paradigmslip.ca/badfaith. April 5th, 2015. An officer shot a man at his home. The next morning, he sat down to write his notes. 10 past 10, he messages a senior officer, making notes now, then sends them. The reply asks whether he should be more specific and quote the use of force policy. The officer pushes back, but a gun pointed at me is pretty straightforward, and then, using policy line in the circumstances feels a bit manufactured. That is the officer's own instinct about his own statement. The senior officer: it's reflective of the training and articulation. I think it's important to state that. Okay. 7 minutes later. Read the change. Yep, that's better. That afternoon, he gave a statement to the RCMP. January 18th, 2017. Under oath. In terms of the drafting of those notes, did you have any advice or any input into what should go into those notes? No. A page earlier, twice more. Any advice from anyone before the statement? No. Nobody gave you any input in terms of your statement or anything along those lines? No. The commission did not have those messages that day. It had them 3 weeks later. Here's what happened in between. His phone was searched under a consent form, April 3rd to April 24th. The software reported one conversation as running March 23rd to March 30th, so it was left out of the report, as it fell outside the time frame that was on the consent to search. The messages inside it ran to April 11th. The analyst went back through the ones he had excluded, 8 more, misstated the same way. In writing, I was unable to explain the timestamp error within the forensic software. One of the 8 was the conversation you just heard. The software company's technical director, the analyst wrote, was not sure where the last activity timestamp information was coming from. The commission's own expert could not explain it either, not without a complete analysis of the entire data set from scratch. And it was not the police who noticed. Commission counsel found messages in an email that were not in the phone records. March 6th, recalled and taken to the messages. The commissioner: it's the obligation to tell the truth, the whole truth. His answer: sure, an omission, and that wasn't my intention. He had not remembered the conversation. The analyst had been promised as a witness. He will be testifying later as to what exactly happened. The witness list, revised a week before the end, doesn't have him. His report went in as paper on the inquiry's last day. That buried conversation ran on into the next day, April 7th, to me, next. Every document in full, paradigmslip.ca/badfaith. Two officers, two sworn accounts of the same order. They cannot both be true. February 2017, the public inquiry. The staff sergeant asked about my detention. I did actually participate in some conversation in regard to the decision to attend his residence and have him detained under the Mental Health Act. Another sergeant, he said, actually led the file. Participate, not direct. Asked whether he had discussed my arrest with the officer who had shot Don Dunphy. I don't recall. I may have. I certainly wouldn't deny it. Reminded he'd said in December he very likely had. There's a very good chance I would have, yes. Here is that conversation, recovered from a deleted thread. 5 o'clock, the afternoon they took me. Arrested Abbas under MHCTA. Saw that. Nice. He's at the hospital now. Loser. Yup. The force's own investigation heard the other version. The sergeant who carried the order in 2018, the staff sergeant came to me, and the direction was to detain, as directed by Officer X. Asked how confident he was. I'm 100% confident in that. His certainty grew as that interview went on, the deputy chief noted. Either way, he wrote, the other officer appeared to know already. What it turned on, the officers were acting pursuant to an order of Officer X to detain A, and that his detention was a foregone conclusion. The same day, the force asked what warrants were available for what I'd written. The supervisor of major crimes, on the files notes, there were no available warrants in relation to Abbas' behavior. No warrant. They used a health statute. October 2024, the officer who came to my door testified that he made the independent decision to detain me based on what he saw, and denied the staff sergeant made it at all. Their own 2018 file says the order came from the staff sergeant. Their own 2021 decision says the officers acted pursuant to it. He described me squatting in the kitchen, holding my head and screaming. Their own 2021 report went through it. It is not in his police report. It is not in his notes. Neither officer behind him noted or recalled it. Some of these details he referred to for the first time 3 years after the fact. That report was not in front of the adjudicator. Its complaint had been struck out on a deadline. At the same hearing, the man who signed that report, the same deputy chief, retired, was asked whether he still believed the staff sergeant had lied to the inquiry. He did. He lied about the email and lied about not being in charge of events on April 7th. Nobody has ever ruled on that. I filed the complaint that asked. So what was all of it protecting? The machinery. Next. Every document in full, paradigmslip.ca/badfaith. Why did any of this happen to me? Their own investigation answered it. Loyalty. The finding, in the force's own decision, the staff sergeant was acting as the best friend and loyal supporter of Constable J, but acting beyond the bounds of his legal authority in doing so. And the sentence after it. My finding of fact that Officer X lied under oath at the inquiry paints all of the rest of his evidence, and I find that he is simply not credible, generally speaking. Then, I do not accept any uncorroborated evidence from Officer X that is favorable to him, a deputy chief of police, in a signed decision about a staff sergeant. The day after the shooting, the two of them leaked confidential information to a reporter. The decision calls it a self-serving media strategy, with a goal of portraying Constable J in a favorable light, a particularly unsavory enterprise for the officers to be engaged in, given that D was recently deceased and could not, obviously, publicly defend his own actions. And what it says a leak like that would amount to, a breach of his oath of office as a police officer, and something that could have obstructed a homicide investigation at its early stages, which would indeed be a serious and potentially criminal matter. Asked about it at the inquiry, he said he couldn't recall doing it, and also that if he had, it was only a name and a location. The decision, those claims, are necessarily mutually exclusive. Both cannot be true at the same time. His forgetting was entirely implausible and rejected as false. The force's own investigator had already counted 8 breaches of the conduct regulations, among them detaining without good and sufficient cause. The rest of the ledger, he made no notes at all, against a policy that reads, "Note-taking is a mandatory requirement for all police officers, regardless of their level of involvement." He literally shut the door on the investigator when she tried to join the meeting about my file. His claim to have been acting in good faith there, the decision says, defies logic. And the sergeant who carried the order was misled by his deliberate withholding of information. Then the order itself. The decision calls it a second unlawful order, to detain A this time under the MHCTA, issued contrary to the requirements of Section 20, in apparent defiance of any understanding reached with senior RNC managers, and prior to the completion of a threat assessment. Unlawful. That is the force's own word for it. No court has ever made that finding. All of it in a document the force wrote about itself and signed. And when a chief finally tried to hold people to account for it, watch what happened to him next. Every document in full, paradigmslip.ca/bad faith. While all of this was under investigation, the police force turned on the man running the investigations. Summer 2020, non-confidence vote against the chief of police. 76% took part, 90% voted no confidence. The results were released, in his words, through a former officer. The former officer had been publicly attacking the chief's leadership on social media. The criminal investigation my complaint had produced was still open. His answer, on the record, the vote was promoted by a few individuals who wish to avoid accountability, and it deflects the narrative away from the proper accountability of a small but noisy minority of members. He called it a transparent and fundamentally misguided attempt at intimidation and coercion, and he would say no more while an internal process ran. He did not step down. The other officer my complaint named was under investigation too. He had claimed the chief was biased against him and asked a court to take him off a complaints hearing. That December, he asked the RCMP to investigate the former justice minister. Political interference in his own case. An outside force took it over on January 11th. The criminal investigation my complaint had produced ended the next day. Months later, that outside force found no evidence of interference. No document connects the files. The dates are all on record. Boland said something else when he took the job. I also made it known to those few officers who abuse their authority that they will be held accountable. June 29, 2021. His deputy chief signs the decision proving my complaint. The words it uses? An abuse of authority by a police officer. He had been given the draft a week before his own retirement date. 2 years later, Chief Boland spoke about it publicly for the first time, on a panel at a police governance conference. It was a concentrated effort by several to push me out the door because I was holding people accountable, and I could not get vacancies filled. In effect, I could not run the RNC. The chief's leaving had been announced 8 weeks before that signature. He was gone by July 31st. 2 men on their way out signed off on my findings. And then my complaint finally reached an adjudicator. Next. Every document in full, paradigmslip.ca/bad faith. I finally got my complaint in front of an adjudicator. It never got a hearing. August 1st, 2024. The Act gives you 6 months. His answer to my not knowing who ordered it? The personal identity of senior staff is not a necessary precursor for the complaint. I should have complained about an order I didn't know existed. He was not comfortable about it. The facts of this case are concerning. The detention complaint alleges that an individual was detained by the state without cause. Fury J granted the complaint's writ of habeas corpus, having concluded the same. A hearing would, in my mind, be desirable. Then, the detention complaint is time-barred. The referral was amended to strike it. What survived was a complaint about testimony and messages. His own view of the limit. It may be unnecessarily short and fail to consider modern policing realities, but it is the legislatively enacted limit. The same ruling found something else. An earlier commissioner failed to comply with his statutory duties. The complainant was owed reasons. He was not provided those reasons. 2 years later, the last door. I'd complained the officer's account of my crisis was built afterwards. The oversight agency read his notebook from that day. It captures only basic identifiers and contains no record of his observations, reasoning, or grounds for detention. The detail is all in the report he wrote the next morning. It also recorded what I told them. There was discussion. I was agitated, arguing my position, and the vehicle data. At my door from 4 minutes past 3 to 17 minutes to 4. The report lists what it reviewed: police notes, police reports, earlier police files, testimony from hearings, 2 interviews. The hospital's own records from that afternoon are not on the list. Then, the reason it closed. As the temporal gap increases, the distinction between deliberate falsehood and imperfect recollection becomes progressively more difficult to establish. The threshold for perjury is not met, 11 years, most of them spent inside these processes. Both decisions reach the Supreme Court by different routes. The complainant gets a right of appeal, the Commission gets none. No right of appeal granted to the Commission, which is obviously more restrictive. It had to persuade the court its route even existed. On my appeal, the Commission argued my side, that the complaint was in time. September 2025, dismissed. The judge called us both the unsuccessful parties and ordered us, jointly and severally, to pay the retired sergeant's costs. The Commission came before the same judge that December. He called its arguments cogent and said the court or another adjudicator could have reached a different conclusion, and dismissed it, because the test was not whether the decision was right, but whether it was reasonable. And the other decision, the one about his testimony, was never reviewed at all. So what does the whole paper trail show? Last one, next. Every document in full. paradigmslip.ca/badfaith. "11 years. Here's what's on paper and who wrote it. The Roan Investigation, 2021. This was a serious and wrongful deprivation of A's liberty and an unwarranted characterization of A as a person with mental health issues arising from an abuse of authority by a police officer. The fact that a person who poses a very low risk to others and suffers no mental illness could be detained by police for social media posts without proper legal authority demonstrates how vulnerable members of the public are to unlawful deprivations of liberty by police officers who abuse their authority." And the sentence this series is named for. The circumstances of this case are something one could imagine happening in a police state, but not in a free, democratic country which is governed by Charter of Rights. Their words, their paper, signed by a Deputy Chief of Police. The report makes 6 recommendations. The first is an apology to officers, to civilian staff, and to the partners of officers affected by his conduct. I read all 6, none of them is addressed to me. And then something I only understood at the end. That report is a finding about my detention, and in 2024, the detention complaint was struck out on a deadline. What survived was a complaint about testimony and messages, so the report had nowhere left to go. It is on the exhibit list of neither hearing that followed, and neither is it in the judgment of the court that reviewed one of them. A review looks at the record the decision maker had. And that's the shape of the whole thing. A court granted the writ, no court has ever ruled on whether my charter rights were breached, there's been no compensation, and the apologies are their own record. One sentence on page 100 of that report, a phone call from the chief. And from the health authority that held me for 6 days, nothing, ever. 9 days after they took me, a local paper reported I'd been charged over the tweet sent to Premier Paul Davis. I never was. The correction ran a month later, a fraction of the size, and only after I'd raised defamatory libel with the police. And it corrected which tweet. It still said I'd been charged. That's the version most people read. Every document in this series is posted in full, unedited, searchable, with a corrections channel. If I've gotten anything wrong, show me, and I'll correct it on the record. The full archive, paradigmslip.ca/badfaith. This was Bad Faith Police State.